Good afternoon, Your Honor. Anita Komorski appearing on behalf of the defendant's appellants. I'll waive any free fire.
Would you do me a favor?
Yes.
And keep your voice up.
I will try.
Thank you.
I always have that problem.
As well,
You can raise the podium if that helps get the microphone.
There's a little
closer.
There's a little
Button
button
underneath.
on the left side.
Show her, Mr. Gonzaga. Well, there you
There
go.
you go.
There you go. She found it on her own.
Good job.
My boss was here once, though, when she broke this podium, so I'm always afraid to touch it.
Okay. Well, so far you're good.
But I will waive any free fire time that I have, but I would like to reserve just 2 minutes for rebuttal. This case presents an issue of statutory construction, but compared to the statutory construction arguments I've heard today, ours seems pretty narrow. We're looking at the impact of the insertion of the phrase death as described in Section 2922A into the Wrongful Death Act. And I know the issues are familiar to this court. They are the same issues that were raised in the Johnson versus Pastoriza case. And the facts in our case are pretty much identical to that case. But what the legislature chose to do was insert this phrase death as described in Section 2922A. And it's our position that the phrase death as described is an expansive phrase. It's not limited to just the type of death referred to in 2922A. And I think that's even how this court in Johnson read that phrase when they stated that it was intended to specifically incorporate and cross-reference 2922A. So I think the language itself, the legislative history, if this court chooses to look at the legislative history, supports our interpretation. This court's decision in Johnson supports our interpretation.
Okay.
It's our position that the Court of Appeals erred. We'd ask the court to reinstate the order granting summary disposition by the trial court.
So you get to preserve a lot of time now.
I guess I have, if there are no questions. All right. Thank you, Your Honors.
See if you can be as concise.
Do you want me to be as brief? Forget about it. Mark Rosado on behalf of the plaintiff appellee. With me at counsel table is Ariana Coulage, the plaintiff's trial attorney in the case. I waive any imposed limitation on asking of questions. This case is obviously not governed by Johnson in light of the fact that Johnson was a pre-2005 amendment of 2922, the Wrongful Death Act. This, of course, this case has to resolve the issue that had to be left open in Johnson, which is what happens when the legislature amended 2922 as it did. And what the legislature did in 2922, as I tried to describe the history of this in my brief, the legislature basically had two options. They could try to expand the concept of an individual or person covered by the Wrongful Death Act. That proved politically unfeasible for various reasons. Instead of expanding the definition of life, they expanded the definition of death. And they did so by adopting certain parts, one part of 2922A, and that is the type of death described in 2922. They decided to take from 2922 the description of death from that statute, which is basically stillbirth or, more importantly and more broadly, death of a fetus. And that's precisely what they did. And that's precisely how the Court of Appeals read this particular trio of statutes when you include 2921 as the other relevant statute here. The fact is that textually, the defendants has a really serious problem in this case, largely because of the fact that the key words here, death as described in 2922A, is not used once in 2922, it is used twice. In the final clause of that statute, it is used with the expression nevertheless, and that, notwithstanding the death of the person injured or death as described in section 2922A. And as I've indicated, and there's been no response by the defendants to this, because I believe there is no response by the defendants to this particular argument, there is no question that with respect to the notwithstanding clause, the final clause of 2922, The fact is, it is only a reference to death. It doesn't matter how the manner is. The other textual difficulty that the defendants present with this is because the defendants have to, in light of the fact, and by the way, this is owing directly to Johnson, because Johnson obviously decided the question of whether 2922A could be based on a passive negligence, and Johnson said no. But in the course of doing that in Johnson, the court said quite correctly, in light of the different language that's used in 2922, that the Wrongful Death Act does allow for a cause of action for omissions, passive negligence. So the defendant's argument in this case is that you must take into 2922, when they use the word death as described in 2922A, you must take those deaths, but you must take beyond the deaths, and you must take the manner of death. The defendant's position is you take the manner of death, in this case, what they obviously want from 2922A is not the deaths themselves. They want the fact that under Johnson, and the way 2922A is written, they want death as caused by an act, an affirmative act. That's the way they want this, that's the way they want 2922A incorporated into 2922. The problem with that, particularly, especially, in light of Johnson's determination that the Wrongful Death Act is different, that the Wrongful Death Act is based on both active and passive negligence, is they have put, if you put these two statutes together, you get a statute that requires active negligence or passive negligence. It's actually, I rewrote it in my brief, and it comes out with some very interesting language as to how this statute is to be read, in the event that the defendant happens to be right in this. Because if you put the entirety of the manner of death, and that's one of the problems the defendants have, the fact is the legislature didn't say in 2922 that it's the manner of death, that is, death by action, death by active negligence. All they said is a death as described in 2922A. But here's the way this statute would read if the defendants were correct. And you tell me whether active or passive negligence does the trick. Whenever the death of a person, injuries resulting in death, or a miscarriage, stillbirth, or the death of an embryo or fetus resulting from a wrongful or negligent act shall be caused by a wrongful, negligent, or fault of another. In other words, if you do exactly what the defendants say, you have incorporated a language that requires active negligence followed immediately by language that says it can be either active or passive. Now, how is a court supposed to read that statute? The point is, textually speaking, once you put this final sentence, the notwithstanding sentence, and you actually take the defendants at their word and incorporate all of 2922A into 2922, including the manner in which the death occurred, you end up with sort of gibberish as to how a cause of action would in fact survive, especially one as this one, which is based on an omission.
Is your client's underlying claim based on Section 2922A?
I'm sorry?
Is your client's underlying claim
Oh,
based on 2922A?
no, it's very funny because this is only a wrongful death claim, and that's a very interesting position. The defendant has tried to, it hasn't been mentioned here in oral argument, but the defendant, sort of reminiscent of this court's decision in Weshy and a couple of other cases, has suggested that you have to filter, that's the wonderful word that was used in these cases, you have to filter through the Wrongful Death Act. The fact is that everybody knows the Wrongful Death Act is not a cause of action. Well, 2922A, which was basically just supposed to be a mirror of the Wrongful Death Act, is not a cause of action either. Okay, and the fact is there is filtering under this court's determinations, prior determinations, including Weshy, but clearly the filtering is a medical malpractice case. This is a medical malpractice case. It would be very interesting if Ms. Komorski gets back up here, ask Ms. Komorski if the caps apply to this case. Will the caps apply to this case? Well, I don't think Ms. Komorski is going to tell you that they don't. And the reason they do is because this is a medical malpractice case. It is not a 2922A.
It's to survive the filter of the Wrongful Death Act, then it's also your position that a surviving fetus would have a claim for prenatal injuries outside of 2922A?
Would they have it outside of 2922A?
What's their pre-existing common law negligence claim?
Well, that common law, a fetus, a viable fetus would have a claim, okay, under the Wrongful Death Act. That's true.
But isn't the question under the Wrongful Death Act not viable, non-viable, but whether a surviving fetus, if the person had survived,
Yes.
Would they have a claim?
Well, the 2922A, if this is your question, does in fact apply not only to the death of a fetus, but also to the injury of the fetus. So I assume that if you had an injury to the fetus that did not result in death, obviously the Wrongful Death Act would not apply, but 2922A would. So the suggestion was made at one point in the defendant's brief that somehow my position negates the effect of it, but that's not true in light of the fact that 2922A does in fact apply to injuries to the fetus as well as death.
There's a second requirement that I'm sort of getting at. The act, neglect, or fault is such as would, if death had not ensued, have entitled the party injured to maintain an action and recover damages.
Yes.
So I'm just, as I understand your position, and I'm not quibbling with it, but that would have to apply to the underlying medical malpractice action. Your theory would be that had the baby survived under a common law, there would have been a claim. Is that right?
Of course. I mean, that's always been a part of the Wrongful Death Act. Always. Yes. And that's part of what was involved in the Weshy case and this court's decision in the Weshy case. So, I mean, putting together textually here, particularly in light of that last clause, the Court of Appeals got this case right. The Court of Appeals determined that what the legislature incorporated, and the history, again, is quite important to understanding this, because the 2005 amendments to 2922 were a product of, I would call it, some misunderstanding of the Michigan Court of Appeals 2003 opinion in McLean, because the 2003 opinion in McLean taught, perhaps inappropriately, but it taught the legislature that perhaps 2922A wasn't doing its job. 2922A wasn't being used appropriately. That's what the legislature saw on the basis of McLean. And what they wanted to do was they realized, especially in light of 2921, which is the statute that says the next section controls all death cases. Part of the legislature's problem here is they didn't account for the fact that they wrote 2921 long before they wrote 2922A. And the fact is they had a statute in place, 2921, which said the next statute governs death cases, and that's the Wrongful Death Act. So what they decided to do was to amend the Wrongful Death Act, which they saw on the basis of the McLean case as the vehicle for processing wrongful death claims. And interestingly, the legislative history that Ms. Komorski even cited said, I know you don't like legislative history too much, but I'll read you this brief thing. The analysis, the Senate fiscal bill analysis for this 2005 amendment is exactly what the Michigan Court of Appeals ruled in this case. Under this bill, the death of an embryo or fetus as described in 2922A would be treated as any other death for purposes of the wrongful death action. That's what the Michigan legislature did when it passed the 2005 amendment of 2922. That's what the Court of Appeals interpreted the statute as saying, and that was right. Questions? Thank you.
Just one or two points I wanted to emphasize. I think the second use of the phrase death as described in Section 2922A in the Wrongful Death Act is just a reference back to 2922A and the allowable deaths allowed under that act. I don't see any difference in the two uses in that statute. And I think even the use in that statute supports our argument that it's only intended to allow the deaths that are allowed under 2922A. And unless there were other questions for me, I'll rest on what we've submitted to the court.
Seeing none, thank you very much. The
Thank
case
you,
is
Your Honor.
submitted, and we are concluded for the day.